Welcome to another Legal Talk on eRadio with myself, Jan, and Hahn attorneys. Today, we're joined by Merilynn du Plessis of the firm, and we will be discussing very briefly just about local authorities. And, the question I think we'll ask today is, can I challenge the decision of a local authority? Merilynn, once again, hello, and welcome back to Legal Talk. I hope you're well.
Thank you, Ian. Yes, it's always a pleasure. It's going very well here. We shall not complain about the weather.
No. Just wrap up nicely, stay nice and warm, and stay away from the germs. That's all. Yeah.
That's it.
So, Merilynn, today's topic, we're going to keep it short because it can get long, but can I challenge the decision of a local authority? You said you want to start with just a quick disclaimer.
Yes, sure. So in that question, it would sound like a simple question, but it kind of delves into a lot of fields of law. And just to keep everyone's attention, and I mean, we attorneys can get very caught up in our legal jargons and our legal definitions. When we speak about this, I won't be referring to any specific acts, but I'll refer to them loosely so that, we can just give an overall overview, I can say, about local authority decisions, if that's okay with you.
Perfect. So, Merilynn, a local authority, that would be your municipality.
That's right. So, as with all of our law, and one of our biggest areas of in looking at this is the Constitution once again. And it seems to me every time we speak, we are stemming back to the Constitution. But the crux of the matter is that the Constitution sets up, I would say, the core functions and duties of our government. And how it does so is, and we call it a separation of powers. However, there isn't really anything in the Act that you will find that gives you a clear definition. But the short and the long is, in order for our government to have checks and balances, the Constitution has broken up the functions and the powers into different categories of authority, if I can say that to you. And it does so by saying, there's three different arms of the separation of powers. It would be the legislative, executive, and judicial. And these three bodies aren't supposed to be regulated in one single piece of legislation, in order that the one can act as a check and a balance to the other. So having said that, a local authority is vested with legislative and executive functions at a provincial level, if I can say that. And that lies then within your municipality. So the Constitution has democrated some powers and functions of a province, and this has gone to the municipality, and that is where your local authority lies in. And that's something to remember when we now discuss, challenging a local authority. But yes, Ian, does that answer your question?
Yes, Merilynn. Yeah, thank you. So, what kind of decisions can we challenge in a local municipality? Just an example.
So that's a very good question, and it actually brings us to the crux of the matter. I believe that anything is reviewable or can be challenged. It's just how you go about it, right? So in this specific scenario, and like I've explained to you, because there's the Constitution has separated the functions into three, can I say, categories, and those categories act as check and balances to each other. You would have to consider whether a decision of a local authority is one of the three following. If it's a legislative function, executive function, And in the separation of powers, judicial is a third, but judicial is only regulated by courts. And then we would break it up with three types. It would be your legislative function, your executive function, and then it would be your administrative function. Because the Constitution has separated them into as checks and balances, your procedure in what type of decision would differ. So let's say, for instance, if it was a decision based on the legislative or the executive function, that would follow a different approach than your administrative. And when I say that, if it is a legislative or executive function, then a person has wide and vast options. This would be bringing to, a specific decision to court based on legality, or the Constitution provides that a higher authority, such as the provincial, can intervene, or over and above that, there's a couple of legislations that deal with those functions. And in those legislative and procedures, they'll always have a remedy that you can seek to challenge a decision, which will be called your internal remedies. Those internal remedies are things such as disputes and appeals, etc. And once those mechanisms have been followed and it still fails, a party then can approach a court. The most important thing I would say is that your internal remedies, as I've just explained, would be exhausted. But if those have been exhausted, then you can either approach the court via what we call a PAJA application. It's in terms of the Promotion of Just Administrative Act. And that is a very specific application, and you can only bring your court proceedings in terms of that act. But that act excludes all decisions that were made under legislative and executive authority. So I would filter it down by saying, the test would be to see whether the decision was an executive or legislative, or whether it's an administrative decision. If it's an executive and legislative decision, you can proceed to court on the basis of legality, which is also enshrined in our Constitution. And if not, your go-to would be the PAJA, and that's where you bring a formal review under court. There is formal rules that regulate that, and in doing so, and in saying that, PAJA is a whole new conversation for a whole new day.
Whoa, PAJA, it sounds like a Indian curry dish or something.
Yeah, and it's also not to be confused with paya, right? Because when you write it down and you read it, it looks the same thing.
Yes.
And it's very frustrating speaking to public officials because, one will refer to paya and it's actually paja. So, it's very technical, but you'll always, the crux of the matter is, you will always be able to challenge a decision.
Yeah.
It will just be about how you want to do it and how much fight you want to muster into that manner in getting what you want.
Yeah, but I mean, you must really feel strongly about it for it to go that far and to carry on doing it like that. And, it will cost you money and a lot of time as well. So you must really feel strongly about it.
Well, and that brings us back to our electricity situations in South Africa, is that, the best type of matters that these procedures are good at is, this would be typically where a whole province is affected by, let's say, an electricity tariff or electricity load shedding or generation, etc. This would be the ideal option.
Well, that's nice because then you've got a lot of people behind you. But I mean, imagine taking on a local authority all by yourself. I mean, that's pretty ridiculous.
Yes, true. But I mean, that's always why we are here, because we make it a little bit more simpler.
Exactly.
And the nice thing about us is that we resolve the problem without going to court 90% of the time.
That's nice.
So,
I like that.
So the nice thing is, in the marketing statement that I'll throw in is that we resolve problems. We don't. Our first go-to is not to litigate into court. So, we've already determined, what the ins or outs are to try and avoid having a matter going to court, but also achieving the desired result.
And that's, of course, at Hahn & Hahn Attorneys, where you are, Merilynn du Plessis. Thank you so much for that, Merilynn.
Thank you, Ian. It was lovely to speaking to you all.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.